Doctors have a very useful exception for them, which is that they don't have to be dragged into court. The lawyers have to go to their office usually to take the testimony.
And the lawyers pay that doctor or medical provider to testify when they go to that doctor or medical provider.
And that's often just absolutely necessary expense. I mean, that expense can be over $1,000. And if your lawyer does settle your case, that is part of the money that is taken into account in determining what your lawyer will be paid, or at least what your lawyer's recompense for. But it's a very necessary expense.
What, in addition to developing the medical part of the file, is the injured worker's lawyer doing now under the current state of the law?
Well, the other chief thing, and we alluded to this a bit earlier, we talked about how it used to be that the main thing was just to prove medically you have a work-related injury. But now the second thing is to prove that you have a diminished wage earning capacity. And let's say you earned $12 an hour, or let's make it better, let's say $20 an hour at the employer at which you got injured, and you cannot do that work anymore. The current law says that the inquiry doesn't stop there. The law now looks to see, well, if Frank can't do the $20 an hour job he did for the ABC company he was working for at the time of injury, is there any other work he's qualified to do that might pay him $20 or even less? But even if it only pays him $12 an hour, some work he finds, say, that's very light that he's able to do, that will impact how much workers' comp benefits he gets, because the workers' comp benefits would be based on the difference between the $20 an hour he was making at the time of injury and the $12 an hour he was making later.
But say the injured worker can't find that job, but the vocational expert says that job exists. What's happening now, given the current state of the law pronounced by the state Supreme Court?
And when you say the vocational expert, in your example, you mean the employer's vocational expert?
Sometimes
well,
both.
Sometimes both, but often it's, to address this second factor, both the plaintiff and the employer most often, will hire the services of a vocational expert, someone who has a college degree and knowing what jobs are available where, they know the official job coding and titles, and they know how many of those jobs exist where. And so the plaintiff attorney's client, the injured worker, his attorney or her attorney will schedule an appointment with one of these vocational experts. You'll meet with the vocational expert. The vocational expert will take your job background, take your history about your training you've had, and then similarly there'll almost always be a similar vocational expert hired by the defendant, who tends to be more slanted toward not finding work. And both of those vocational experts have the duty to take the information they've learned about you and to use that to find other work. Now, if you've been three things in your life, let's say you've been a tool and guide person, and you've been a newspaper delivery guy early in your career, and you've been a cook, the analysis you might think would be sufficient to say, can Frank do any of those three jobs? But that is one of the questions, but it's not the only question. So if you're Frank and you're injured at the tool and die job, you still have to say, can Frank still deliver newspapers? Can Frank still be a cook? If Frank can still be a cook with his injury, then the type of money he would be able to earn at those types of jobs could be imputed to him, could be credited toward him, thereby lessening the value of his workers' comp claim. But it has to be real jobs found. It can't just be a vocational expert saying, well, I think there might be some cook jobs. They have to find real jobs.
What do you think about that interpretation of the law?
The actual jobs? Or the whole field of vocational?
The whole field of vocational.
Well, when I was a defense attorney, I thought it was a good idea. Now that I'm a plaintiff attorney, I don't. I mean, you can you know, in the abstract, say that it's a valid point, because if somebody, one of the easy examples I used to give in my seminars for defense-oriented clients was, let's say you have a typist, and her will say job is typing. That's it. Now, on a rare occasion, she's asked to lift a box here and there, and let's say on one of those rare occasions, she lifted a box. It turned out to be much heavier than she thought, and she got a major injury in her back. Well, let's say that over time the injury resolves, at least to some extent. Her doctor still thinks that she should have a permanent restriction now of no lifting over 40 pounds, or 30 even, let's say 30. Well, a typist probably can do their job description with a 30-pound weightlifting restriction. And so even though you've been injured on the job, the question about whether you've actually suffered a diminishment of your wage earning capacity in that example might very well be that you haven't, because you're still able to do all the duties normally expected of you as a typist.
So the plaintiff's lawyer, the injured worker's lawyer, it takes medical deposition testimony, now is further developing vocational proofs by having a vocational expert evaluate her or his client, and then taking that vocational expert's deposition. What happens next after, we'll get to the defense in a minute, after the defense does the same thing on that side? What happens after all these medical and vocational depositions are taken?
Those are the main two kinds of depositions allowed in workers' comp. Now, there's still other witnesses to think about. You know, there may be a key witness or two that saw you get injured. Let's say your employer is disputing that it happened how you say it happened. Well, you want to get those people that can buttress your case and support your version of events. There's also important time that has to be spent between you, the injured worker, and your attorney in making sure that you've practiced what your testimony will be and so that you're ready for trial. So anything that your lawyer thinks is going to end up being part of the trial, a supporting witness, your testimony, the medical records, perhaps other documents such as your school records sometimes, everything has to be lined up before trial.
And let's talk about the defense and the preparation of the case from the defense perspective. Depositions taken again, often of the insurer's choice of a deponent.
Because the treating doctors, as a general rule, will often support or be assumed to support the injured worker. I mean, they know that person personally. They've been trying to help them. They're sympathetic typically. Now, there's exceptions to that, but most treaters will be have their testimony taken by the injured worker's attorney. You take testimony from people you think are going to help your case. Now, if you get a rogue treater who is actually questioning the claim, the defense for the employer may actually take that doctor's testimony. But typically, the medical expert that is left for the employer to take are these one-shot examiners. There's businesses set up all around the country, and there's plenty in Michigan. We'll call them the alphabet soups because they're usually identified by 3 letters that are initials for their business. Something like certified medical consultants would be CMC. So everybody knows the initials. All the lawyers do. And one of the doctors, now these can be doctors that have a practice. They can be seen every day in hospitals or in their offices and be doing surgeries for their patients, but they can also spend some time doing these one-shot examinations. And the expectation is that they know who's buttering their bread, and they typically will be able to word a report that's helpful to the employer. And so one of the duties of the plaintiff's attorney, the injured worker's attorney, is to just warn their client, hey, you got to go to this, be honest, but it probably, you can't, even if the doctor's nice to you, you probably cannot expect a great report.
And additionally, as you've already described, the defense lawyer also typically has now a vocational rehabilitation consultant to evaluate the injured worker and make an assessment from the defense perspective.
And similar to what we talked about with plaintiffs, the defense may also have other witnesses, like maybe a worker who swears that it didn't happen like you said. But there's also one other type of witness that defense has, which is a surveillance investigator.
Tell us about that.
They're, well, to be a true investigator in Michigan, you have to be licensed, although if a licensed investigator owns their firm, I believe that people working under them can do surveillance without a license. They get their authority under the umbrella of the person who owns the organization. But these are people that spy on you, and they will be in a van with darkened windows and have a camera pointed at you. And I tell injured workers that I represent for workers' comp, I mean, the government has no inclination nor money to conduct surveillance on Social Security clients, but for workers' comp, the employer or their insurer or their third-party administrator fairly often will hire a surveillance investigator at least once. You know, and then if the surveillance investigator happens to get something they consider juicy, it may be again. So what I tell workers' comp clients is that just assume you're being watched.
I think that's good advice, especially now, because as you suggested, there are a fewer number of claims. I think the insurers and the third-party administrators are able to watch more on an individual basis than they used to watch, just because there are fewer people in the field who need to be watched.
And you know, you can have a true bad injury, and for whatever reason, your brother's in town, so he really wants you to help him load his car, and you think, what the heck, I'll probably hurt even more the next day, but I'm going to help my brother. And don't you know, that's the day the surveillance investigator catches you carrying these boxes that you never tried to do before and you never tried to do after. So just assume you can't get away with anything like that.